In this video, I'm continuing my onslaught of the trolls and everything, putting out documents that are going to make the anti-sovereign circles just cringe with chagrin at the truth that's being disseminated over at High Frequency Radio. But in this document, this is a court case where an attorney came as an expert witness and basically testified that the banks don't create money. You got in the a lot of case law out there on vapor money theory. If you just Google vapor money theory, you'll see that. And a lot of people like to use that. Well, you're not discharging debt thing. Is not real. There is money. What are you stupid sovereigns talking about? All of you guys just don't want to follow any law. You're nincompoops when in actuality, these people, either one or two things, are agents, or they sit around and watch fucking TV all day and believe everything that Fox News tells them. They're just sheeple, or lapdogs. Let's call them that. Don't call me. Let's call them lapdogs and sheeple. So in the lapdog and sheeple circles, they're going to call you names and say, you don't want to follow any law, you're un-American, anti-patriot, you're going to get arrested. I can't wait to see the windows get knocked out in your car, all this shit, just negative, nothing Christian-like or anything like that. No spirit of love, nothing like that. No understanding, nothing, But anyway, here today, we're going to be discussing one of the four rules. There isn't any money, y'all. Okay, they're loaning you your own money. Now, I got several videos on the internet that talk about this. Before I begin, I'm gonna recommend that if you're trying to discharge debt or you're in court or anything, there are a couple of documents that I'm going to suggest that you read. The first one is The Banker's Secret Manual by Tom Schaft. I'm going to suggest that you get that and read that. All of Tom Schaft. He has a couple of other documents out too, but that one is the first one I would suggest. And it has the documents in the appendix area that you need to file. You don't have to ask about where to get documents from. It has some very good documents in the back for you to file, and it has an exhaustive treatise on the UCC and what is exactly going on. Tom Schaft was a CPA on this website. I do have one of the videos from one of his students. He's also a CPA, and he breaks down to you everything that is going on with this banking as far as doing the accounting. This is the accounting aspect of it. You got to learn what accounting is. All right. So the first one is, yes, that. Then I'm going to suggest that you read Modern Money Mechanics, of course, issued by the Federal Reserve. Read their document. I'm going to also suggest that you read the Financial Accounting Standards Board Statement 95, and where it talks on page 21, where it talks about financial institutions. And it is a very, very good chapter, for you to read. And you can see right here, it tells you, it talks about the exposure draft. It says, I go right here. It says banks who responded to the exposure draft generally said that their cash flows are much more complex and interrelated than those of other enterprises, and that the bank's cash flows are much larger in relation to net income and net assets than are the cash flows of a non-financial enterprise. They commented that a bank creates money through its lending activities. That, they said, makes cash the product of a bank's earning activities, just as finished goods are the product of a manufacturer's earning activities. So basically, like Toys R Us might, manufacture some stuff. Banks does the same thing. They manufacture money. That money is their product. They manufacture it. They're letting you know right here. It's an exposure draft. It was getting, trying to get them to basically also reveal to the public all of your rights as it relates to negotiable instruments, because only if you have full disclosure can you waive them. They don't want you to have full disclosure so they can help you. They want you to get full disclosure so they can waive their rights and take stuff from you. But that's neither here or there. We'll go into that on another video. But you definitely need to read the Financial Accounting Standards Board Statement 95. You need to read the Banker's Secret Manual. You need to read Modern Money Mechanics. And, of course, the last one is this one, the Affidavit of Walker Todd. In this particular document, I've used this as an exhibit in a court case before. And, man, did it just shake them down to their boots. The thing about it is that, they're going to come in and say, one of the things you're going to hear in court is especially if you try to tender a international bill of exchange as a for set-off purposes to offset an obligation to the public, and they're going to tell you that it's a worthless piece of paper, as if Federal Reserve notes are worth anything. And it tells you right there in their pamphlet that Federal Reserve notes have no intrinsic value whatsoever. You know, but boy, I'm gonna let Walker Todd tell it to you. Walker Todd is an attorney. Trolls, before you comment, this is an attorney. This is one of your own. Okay, I don't know what he was, if he was smoking something or what. You pissed him off. You know how y'all do. Y'all got a whole bunch. That's how we found out about all this stuff. Y'all be talking about the UCC and all this, man, back in the day, how we judges put this out there. Y'all done took off the bench and everything. You pissed them off and they turned their back on you and started telling the people what was going on. Just like whistleblowing. That's where all this is coming from. Whistleblowing. So, this is just whistleblower information. I don't know if he was dry snitching in this case or what, but he gives it up in this case right here. This is study material. You understand me? So if you're out there trying to discharge some debt, or you have a foreclosure case or something like that, okay, I would advise you to do an administrative process. It is necessary. And then also do a secure party process also. And then tender these people some sort of negotiable instrument, because there is no money, okay? They are taking all the credit from you, and this is what Walker Todd is going to explain to you in this particular document. He's explaining how the banks, you give them a promissory note, and they taking that and monetizing that and tricking your ass, okay? This is what it's all about, and it's an attorney telling you, okay? It is a real case. This is a copy of it. I got the original copy from the original filing, but this is just a copy of it made so we can read it very clearly and so forth on here. But I got a copy of the original too. Here, you can see it right here. Okay. And we're going to go through this. All right. And read it and study it. Listen to this. Okay. Let's get on into it. Peace to the gods. Affidavit of Walker Todd, expert witness for defendants. Now comes the affiant Walker F. Todd, a citizen of the United States and the state of Ohio, over the age of 21 years, and declares as follows, under penalty of perjury: that I am familiar with the promissory note and disbursement request and authorization dated November 23, 1999, together sometimes referred to in other documents filed by defendants in this case as the alleged agreement between defendants and plaintiff, but called the note in this affidavit. If called as a witness, I would testify as stated herein. I make this affidavit based on my own personal knowledge of the legal, economic, and historical principles stated herein, except that I have relied entirely on documents provided to me, including the note, regarding certain facts at issue in this case, of which I previously had no direct and personal knowledge. I'm making this affidavit based on my experience and expertise as an attorney, economist, research writer, and teacher. I'm confident to make the following statements. Professional background and qualifications. My qualifications as an expert witness in monetary and banking instruments are as follows. For 20 years, I worked as an attorney and legal officer for the legal departments of the Federal Reserve Banks of New York and Cleveland. Among other things, I was assigned responsibility for questions involving both novel and routine notes, bonds, bankers' acceptances, securities, and other financial instruments in connection with my work for the Reserve Bank's discount windows and parts of the open market trading desk function in New York. In addition, for 9 years, I worked as an economic research officer at the Federal Reserve Bank of Cleveland. I became one of the Federal Reserve System's recognized experts on the legal theory of central banking and the pledging of notes, bonds, and other financial instruments at the discount window to enable the Federal Reserve to make advances of credit that became or could become money. I also have read extensive treatises on the legal and financial history of money and banking and have published several articles covering all of the subjects just mentioned.
I have served as an expert witness in several trials involving banking practices and monetary instruments. A summary biographical sketch and resume, including further details of my work experience, readings, publications, and education, will be tendered to defendants and may be made available to the court and to plaintiff counsel upon request. Generally accepted accounting principles. Banks are required to adhere to generally accepted accounting principles, GAAP. The requirement for banks to follow generally accepted accounting principles, which is very important for you to understand, can be found at 12 United States Code, subsection 1831N. And when you go down here in section 2, you see standards, uniform accounting principles consistent with GAAP. Subject to the requirements of this chapter and any other provision of federal law, the accounting principles applicable to reports or statements required to be filed with federal banking agencies by all insured depository institutions shall be uniform and consistent with generally accepted accounting principles. GAAP follows an accounting convention that lies at the heart of the double-entry bookkeeping system called the matching principle. This principle works as follows. When a bank accepts bullion, coin, currency, checks, drafts, promissory notes, or any other similar instruments, hereinafter instruments, from customers and deposits or records the instruments as assets, it must record offsetting liabilities that match the assets that is accepted from customers. The liabilities represent the amounts that the bank owes the customer, funds accepted from customers.
Okay, I'm going to explain this to you in very simple terms that anyone can understand. Okay. Here is a promissory note that you signed for a mortgage. It is a promissory note. Here is a $100 bill Federal Reserve note. It is a promissory note. You are giving these to financial institutions, okay, which I'm going to show you just in a little bit what a financial institution is. When you are at a real estate closing, you are at a financial institution. All right, so you are giving them a negotiable instrument. You're making a deposit. Okay, doesn't matter if you do it at the closing table or if you walk inside of a bank. All right, they're becoming the holder of an instrument. You are the holder in due course of that instrument. You're making a deposit. You're giving them an asset. They're putting it on their books, but they're also simultaneously required to lodge it as a liability in their books as well because they owe it back to you. There's no difference. There's no difference in this promissory note and when you go in the bank and you give them a Federal Reserve note. Are you starting to understand what we're talking about? This is key.
In a fractional reserve banking system like the United States banking system, most of the funds advanced to borrowers, assets of the banks, are created by the banks themselves and are not merely transferred from one set of depositors to another set of borrowers. Relevance of subtle distinctions about types of money. From my study of historical and economic writings on the subject, I conclude that a common misconception about the nature of money unfortunately has been perpetuated in the U.S. monetary and banking systems, especially since the 1930s. In classical economic theory, once economic exchange has moved beyond the barter stage, there are two types of money of exchange and money of account. For nearly 300 years in both Europe and the United States, confusion about the distinctiveness of these two concepts has led to persistent attempts to treat money of account as the equivalent of money of exchange. In reality, especially in a fractional reserve banking system, a comparatively small amount of money of exchange, in other words, gold, silver, and official currency notes, may support a vastly larger quantity of business transactions denominated in money of account. The sum of these transactions is the sum of credit extensions in the economy. With the exception of customary stores of value like gold and silver, the monetary base of the economy largely consists of credit instruments. Against this background, I conclude that the note, despite some language about lawful money explained below, clearly contemplates both disbursement of funds and eventual repayment or settlement in money of account. That is, money of exchange would be welcome, but is not required to repay or settle the note. The factual basis of this conclusion is the reference in the disbursement request and authorization to repayment of $95,905.16 to Michigan National Bank from the proceeds of the note. That was an exchange of the credit of Bank 1, plaintiff, for credit apparently and previously extended to defendants by Michigan National Bank. Also, there is no reason to believe that plaintiff would refuse a substitution of the credit of another bank or banker as complete payment of the defendant's repayment obligation under the note. As a private sovereign American citizen under the Republic, you are in essence a private banker. You're a private banker because you have the capability of writing a note, writing a promise to pay that's backed by your labor. It's nothing new. The colonists did these, had script that they wrote, and go and do your research. This same thing is available to you in the private now. And you also need to know exactly what a financial institution is. A lot of people are under the assumption they think they know what a financial institution is. But if you turn to 31 U.S. Code 5312, definitions and application, right here under Section 2, you see financial institution means. An insured bank is defined in Section 3H of the Federal Deposit Insurance Act, 12 U.S.C. 1813H. A commercial bank or trust company, a private banker, an agency or branch of a foreign bank in the United States, any credit union, a thrift institution, a broker or dealer registered with the Securities and Exchange Commission under the Securities Exchange Act of 1934, 15 U.S.C. 78A, and all that follows. H, a broker or dealer in securities or commodities. I, an investment bank or an investment company. J, a currency exchange. K, an issuer, redeemer, or cashier of traveler's checks, money orders, or similar instruments. L, an operator of a credit card system. M, an insurance company. N, a dealer in precious metals, stones, or jewels. O, a pawnbroker. P, a loan or finance company. Q, a travel agency. R, a licensed sender of money or any other person who engages as a business in the transmission of funds, including any person who engages as a business in an informal money transfer system or any network of people who engage as a business in facilitating the transfer of money domestically or internationally outside of the conventional financial institution system. S, a telegraph company. T, a business engaged in vehicle sales, including automobile, airplane, and boat sales. Those are your dealerships. U, persons involved in real estate closings and settlements. Aren't you a person that's involved in a real estate closing and a settlement? V, the United States Postal Service. I didn't know the post office was a financial institution. W, an agency of the United States government or of a state or a local government carrying out a duty or power of a business described in this paragraph. X, a casino, gambling casino, or gaming establishment with an annual gaming revenue of more than $1 million, which I is licensed as a casino, gambling casino, or gaming establishment under the laws of any state or any political subdivision of any state. Or 2, in an Indian gaming operation conducted under or pursuant to the Indian Gaming Regulatory Act or other than an operation which is limited to Class 1 gaming as defined in Section 4.6 of such act. Y, any business or agency which engages in any activity which the Secretary of the Treasury determines by regulation to be an activity which is similar to, related to, or a substitute for any activity in which a business described in this paragraph is authorized to engage. Or Z, any other business designated by the Secretary whose cash transactions have a high degree of usefulness in criminal, tax, or regulatory matters. And those are your 26 financial institutions. I bet you didn't know. This is a case about exchange of money of account, credit, not about exchanges of money of exchange, lawful money, or even legal tender. Ironically, the note explicitly refers to repayment in lawful money of the United States of America. See Promise to Pay clause. Traditionally and legally, Congress defines the phrase lawful money for the United States. Lawful money was the form of money of exchange that the federal government or any state could be required by statute to receive in payment of taxes or other debts. Traditionally, as defined by Congress, lawful money only included gold, silver, and currency notes redeemable for gold or silver on demand. In a banking law context, lawful money was only those forms of money of exchange, the forms just mentioned, plus U.S. bonds and notes redeemable for gold, that constituted the reserves of a national bank prior to 1913, date of creation of the Federal Reserve Bank. See Lawful Money, Webster's New International Dictionary, 2nd edition, 1950. In light of these facts, I conclude that plaintiff and defendants exchanged reciprocal credits involving money of account and not money of exchange. No lawful money was or probably ever would be dispersed by either side in the covered transactions. This conclusion also is consistent with the bookkeeping entries that underlie the loan account in dispute in the present case. Moreover, it is puzzling why plaintiff will retain the archaic language lawful money of the United States of America in an otherwise modern-seeming note. It is possible that this language is merely a legacy from the pre-1933 era. Modern credit agreements might include repayment language such as, the repayment obligation under this agreement shall continue until payment is received in fully and finally collectible funds, which avoids the entire question of, in what form of money or credit is the repayment obligation due. Legal tender, a related concept, but one that is economically inferior to lawful money because it allows payment in instruments that cannot be redeemed for gold or silver on demand, has been the form of money of exchange commonly used in the United States since 1933, when domestic private gold transactions were suspended until 1974. Basically, legal tender is whatever the government says that it is. The most common form of legal tender today is Federal Reserve notes, which by law cannot be redeemed for gold since 1934 or since 1964 for silver. See 31 United States Code, Section 5103, 5118B, and 5119A. Legal tender under the Uniform Commercial Code, Section 1-201-24, official comment, is a concept that sometimes surfaces in cases of this nature. The referenced official comment notes that the definition of money is not limited to legal tender under the UCC. Money is defined in Section 1-201-24 as a medium of exchange authorized or adopted by a domestic or foreign government and includes a monetary unit of account established by an intergovernmental organization or by agreement between two or more nations. The relevant official comment states that the test adopted in that of sanction of government, whether by authorization before issue or adoption afterward, which recognizes the circulating medium as a part of the official currency of that government. The narrow view that money is limited to legal tender is rejected. Thus, I conclude that the UCC tends to validate the classical theoretical view of money. How banks began to lend their own credit instead of real money. In my opinion, the best sources of information on the origins and use of credit as money are in Alfred Marshall's Money, Credit, and Commerce, page 249 through 251, 1929, and Charles P. Kindleberger, A Financial History of Western Europe, pages 50 through 53, 1984. A synthesis of these sources as applied to the facts of the present case is as follows. As commercial banks and discount houses, private bankers became established in parts of Europe, especially Great Britain, and North America by the mid-19th century, they commonly made loans to borrowers by extending their own credit to the borrowers or, at the borrower's direction, to third parties. The typical form of such extensions of credit was drafts or bills of exchange drawn upon themselves, claims on the credit of the drawees, instead of disbursements of bullion, coin, or other forms of money. In transactions with third parties, these drafts and bills came to serve most of the ordinary functions of money. The third parties had to determine for themselves whether such credit money had value and, if so, how much. The Federal Reserve Act of 1913 was drafted with this model of the commercial economy in mind and provided at least two mechanisms, the discount window and the open market trading desk, by which certain types of bankers' credits could be exchanged for Federal Reserve credits, which in turn could be withdrawn in lawful money. Credit at the Federal Reserve eventually became the principal form of monetary reserves of the commercial banking system, especially after the suspension of domestic transactions in gold in 1933. Thus, credit money is not alien to the current official monetary system. It is just rarely used as a device for the creation of Federal Reserve credit that, in turn, in the form of either Federal Reserve notes or bank deposits at Federal Reserve banks, functions as money in the current monetary system. In fact, a means by which the Federal Reserve expands the money supply, loosely defined, is to set bank reserve requirements, currently usually 10% of demand liabilities, at levels that would encourage banks to extend new credit to borrowers on their own books that third parties would have to present to the same bank for redemption, thus leading to an expansion of bank-created credit money. In the modern economy, many non-bank providers of credit also extend book credit to their customers without previously setting aside an equivalent amount of monetary reserves. Credit card line of credit access checks issued by non-banks are a good example of this type of credit, which also causes an expansion of the aggregate quantity of credit money. The discussion of money taking from Federal Reserve and other modern sources in paragraph 11 and what follows is consistent with the account of the origins of the use of bank credit as money in this paragraph. Advances of bank credit as the equivalent of money. Plaintiff apparently asserts that the defendant signed a promise to pay, such as a note or credit application, collectively the note, in exchange for the plaintiff's advance of funds, credit, or some type of money to or on behalf of defendant. However, the bookkeeping entries required by application of GAAP and the Federal Reserve's own writing should trigger close scrutiny of plaintiff's apparent assertions that it lent its funds, credit, or money to or on behalf of defendants, thereby causing them to owe the plaintiff $400,000. According to the bookkeeping entries shown or otherwise described to me and application of GAAP, the defendants allegedly were to tender some form of money. Lawful money of the United States of America is the type of money explicitly called for in the note. Securities or other capital equivalent to money, funds, credit, or something else of value in exchange, money of exchange, loosely defined, collectively referred to herein as money, to repay what the plaintiff claims was the money lent to the defendants. It is not an unreasonable argument to state that plaintiff apparently changed the economic substance of the transaction from that contemplated in the credit application form, agreement, notes, or other similar instruments that the defendants executed, thereby changing the cost and risk to the defendants. At most, the plaintiff extended its own credit, money of account, but the defendants were required to repay in money, money of exchange, and lawful money at that, which creates at least the inference of inequality of obligations on the two sides of the transaction. Money, including lawful money, is to be exchanged for bank credit. Modern authorities on money. To understand what occurred between plaintiff and defendants concerning the alleged loan of money, or, more accurately, credit, it is helpful to review a modern Federal Reserve description of a bank's lending process. See David H. Friedman's Money in Banking, 4th edition, 1984, apparently already introduced into this case. The commercial bank lending process is similar to that of a thrift in that the receipt of cash from depositors increases both its assets and its deposit liabilities, which enables it to make additional loans and investments. When a commercial bank makes a business loan, it accepts as an asset the borrower's debt obligation, the promise to repay, and creates a liability on its books in the form of a demand deposit in the amount of the loan. Consumer loans are funded similarly. Therefore, the bank's original bookkeeping entry should show an increase in the amount of the asset credited on the asset side of its books and a corresponding increase equal to the value of the asset on the liability side of its books. This would show that the bank received the customer's signed promise to repay as an asset, thus monetizing the customer's signature and creating on its books a liability in the form of a demand deposit or other demand liability of the bank. The bank then usually would hold this demand deposit in a transaction account on behalf of the customer. Instead of the bank lending its money or other asset to the customer, as the customer reasonably might believe from the face of the note, the bank created funds for the customer's transaction account without the customer's permission, authorization, or knowledge and delivered the credit on its own books representing those funds to the customer, meanwhile alleging that the bank lent the customer money. If plaintiff's response to this line of arguments is to the effect that it acknowledges that it lent credit or issued credit instead of money, one might refer to Thomas P. Fitch's Barron's Business Guide Dictionary of Banking Terms. Credit banking, third sense, bookkeeping entry representing a deposit of funds into an account. But plaintiff's loan agreement apparently avoids claiming that the bank actually lent the defendants money. They apparently state in the agreement that the defendants are obligated to repay plaintiff's principal and interest for the valuable consideration money the banks gave the customer borrower. The loan agreement and note apparently still delete any reference to the bank's receipt of actual cash value from the defendants, an exchange of that receipt for actual cash value that the plaintiff's banker returned. According to the Federal Reserve Bank of New York, money is anything that has value that banks and people accept as money. Money does not have to be issued by the government. For example, David H. Friedman, I Bet You Thought, page 9, Federal Reserve Bank of New York, 4th edition, 1984, apparently already introduced into this case, explains that banks create new money by depositing IOUs, promissory notes, offset by bank liabilities called checking account balances. Page 5 says, money doesn't have to be intrinsically valuable, be issued by government, or be in any special form. The publication Anne-Marie L. Gonsi, Modern Money Mechanics, pages 7 through 33, Federal Reserve Bank of Chicago, revised edition June of 1992, apparently already introduced into this case, contains standard bookkeeping entries demonstrating that money ordinarily is recorded as a bank asset, while a bank liability is evidence of money that a bank owes. The bookkeeping entries tend to prove that banks accept cash, checks, drafts, and promissory notes / credit agreements, assets, as money deposited to create credit on checkbook money that are bank liabilities, which shows that, absent any right of set-off, banks owe money to persons who deposit money. Cash, money of exchange, is money, and credit or promissory notes, money of account, become money when bank deposit promissory notes with the intent of treating them like deposits of cash. See 12 U.S.C. Section 1813 L1, definition of deposit under Federal Deposit Insurance Act. The plaintiff acts in the capacity of a lending or banking institution, and the newly issued credit or money is similar or equivalent to a promissory note, which may be treated as a deposit of money when received by the lending bank. Federal Reserve Bank of Dallas publication Money and Banking, page 11, explains that when banks grant loans, they create new money. The new money is created because a new loan becomes a deposit just like a paycheck does. Modern Money Mechanics, page 6 says, what they, banks, do when they make loans is to accept promissory notes in exchange for credits to the borrower's transaction accounts. The next sentence on the same page explains that the bank's assets and liabilities increase by the amount of the loans. Commentary and summary of argument. Plaintiff apparently accepted the defendant's note and credit application, money of account, in exchange for its own credit, also money of account, and deposited that credit into an account with the defendant's names on the account, as well as apparently issuing its own credit for $95,905.16 to Michigan National Bank for the account of the defendants. One reasonably might argue that the plaintiff recorded the note or credit application as a loan, money of account, from the defendants to the plaintiff, and that the plaintiff then became the borrower or an equivalent amount of money of account from the defendants. The plaintiff, in fact, never lent any of its own pre-existing money, credit, or assets as consideration to purchase the note or credit agreement from the defendants. When the plaintiff deposited the defendant's $400,000 or newly issued credit into an account, the plaintiff created from $360,000 to $400,000 of new money. The nominal principal amount less up to 10% or $40,000 of reserves that the Federal Reserve would require against a demand deposit of this size. The plaintiff received $400,000 of credit money of account from the defendants as an asset. GAAP ordinarily would require that the plaintiff record a liability account, crediting the defendant's deposit account, showing that the plaintiff owes $400,000 of money to the defendants, just as if the defendants were to deposit cash or a payroll check into their account. The following appears to be a disputed fact in this case about which I have insufficient information on which to form a conclusion. I infer that it is alleged that the plaintiff refused to lend the plaintiff's own money or assets and recorded a $400,000 loan from the defendants to the plaintiff, which arguably was a $400,000 deposit of money of account by the defendants, and then when the plaintiff repaid the defendants by paying its own credit, money of account, in the amount of $400,000 to third-party sellers of goods and services for the account of defendants, the defendants were repaid their loan to plaintiff and the transaction was complete. I do not have sufficient knowledge of the facts in this case to form a conclusion on the following disputed points. None of the following material facts are disclosed in the credit application or note or were advertised by plaintiff to prove that the defendants are the true lenders and the plaintiff is the true borrower. The plaintiff is trying to use the credit application form or the note to persuade and deceive the defendants into believing that the opposite occurred and that the defendants were the borrower and not the lender. The following point is undisputed. The defendant's loan of their credit to plaintiff, when issued and paid from their deposit or credit account at plaintiff, became money in the Federal Reserve System, subject to a reduction of up to 10% for reserve requirements, as the newly issued credit was paid pursuant to written orders, including checks and wire transfers to sellers of goods and services for the account of defendants. Conclusion. Based on the foregoing, plaintiff is using the defendant's note for its own purposes, and it remains to be proven whether plaintiff has incurred any financial loss or actual damages. I do not have sufficient information to form a conclusion on this point. In any case, the inclusion of the lawful money language in the repayment clause of the note is confusing at best, and in fact may be misleading in the context described above. Okay, and let me tell you why it's very important that you understand what this man is talking about in this particular document. This does not just relate to discharging mortgages or credit cards. This has a lot to do with also criminal cases as well. You have to understand, when we say there is no money, that is an important thing for you to understand. When you live in a society when there is no constitutionally mandated money, because it tells you very clearly in the Constitution that debts can only be paid with gold or silver. Okay, so they had to take you into a private jurisdiction, okay, and start to allow something like the Federal Reserve to come into existence. This is something that the trolls don't want to talk about. And a word to the trolls real quick. You coming on my page telling me we don't understand. You have to understand something. We look at you as intellectual inferiors. We don't have any respect for you because you're intellectually inferior. Your arguments stem from a lack of understanding, first of all, of principles. Everything that we talk about is derived from principles, like Justice Wilson said in his speech to the students in Philadelphia when they said, well, sir, how am I going to study all of these laws? It's so vast. And he said, you don't have to study all these laws. Master the principles. And that's with anything in life. When you know the principles, you can have a discussion about anything. Principles are few, methods are many. So there are 7 principles in the Constitution, and they are popular sovereignty, republicanism, federalism, separation of powers, checks and balances, limited government, and individual rights. And the ones that I like to concentrate on is federalism and separation of powers. In particular, separation of powers. This is something that the trolls don't seem to understand, that we have a government of separation of powers. And it clearly tells you in the Constitution that the legislature can create a court system. That's under Article 1, Section 8, Clause 9. They can regulate commerce. That's Article 1, Section 8, Clause 3. And their jurisdiction only extends 10 miles square in D.C. as well as all of their insular possessions. And that's Article 1, Section 8, Clause 17. So when you get a thorough understanding of these things, and you look at the court system and you look at what's being said and what professors are writing. On my website, I collect all of these law reviews. All these professors are saying the same thing. You know, I'm going to start reading them and just putting them up here for these people and everything. This is why we're looking at you in this way, that you're an intellectual inferior or you're an agent. It can only be those two things. The agents have an interest in not of us not understanding, because it's like I said, in the criminal cases, since there is no money, value has to be obtained through interest in things. This is why, and here in Georgia, in OCGA 1711, when you're found guilty of a crime, they put a lien on you. This is also why when you look at the 5th sense of the word of charge in a Black's Law Dictionary, used in 8th edition, you will see that one of the senses is lien, that they put a lien against you. That lien can be converted into a bond and then be put in a pool of securities and sold and discounted and sold on the markets. This is what we are talking about. We're not talking about statutes and you not being able to drive and all this kind of shit, all these really frivolous arguments that you like to bring up to try to in some kind of way insinuate that we should not be governing ourselves or something like that. When I drive every day and I never see anybody driving the speed limit. Not one person do I see any day driving the speed limit. Everybody I know drives the speed limit of 10, 15, 20 miles over the posted speed limit everywhere I go. This is what I see. And they see it too. All of you see it. So don't act like having a driver's license, all this regulation activity is doing something for public safety, because it's not. It's not doing anything. So let's deal with reality, okay? But that's neither here nor there. The point is, and what I'm saying is that you people don't understand law. You try to concentrate on statutes. I have books here with me where a professor tells you straight up that a statute is not a law. They try to pass off codes like United States Code like it's a law. It's a code. It's a code. The law is the Constitution. The law is the common law. Okay, these are derivatives. Okay, you're dealing with a derivative of the law. That's what a statute is. It's a derivative of the law. I'm dealing with the substance of the law, the origin of law, the source of law. Okay, is what we're talking about. And you don't seem to understand that point. Okay, I understand jurisdiction. I understand public rights doctrine. I understand the ambit of delegated authority that's been delegated to the political branches of government, Article 1 and Article 2. I understand it. I see it very clearly. But I also see where you're deceiving people, trying to act like corporation. The United States is not a corporation, trying to act like, that these courts are some sort of judicial courts under the judicial branch of government. They're just called judicial officers. You can call a damn tennis judge, or damn judge under a damn boxing match a judge. They just give them these titled judges. They're administrators. They're not judges. Congress is in control of these people. That's what federalism is. When you say federal government, you're talking about the legislature. You're talking about Congress. Okay, so we understand this. I see this everywhere. I read law books. So I look at you as an intellectual inferior, and I challenge you, okay, because I'm going to be coming harder and harder. This is all this little stuff I'm giving right now. This is just for the beginners. They coming on my pages and everything, posting stuff. I'm like, man, what's wrong with you? These audio books, these help people get started reading. I haven't even started dropping the shit on you yet. I haven't started posting, reading the whole case from beginning to end and then breaking down everything in it. I haven't started doing that, but I am going to do that because every time y'all come on here and you try to posture yourself as if you're some authority, because if you are agent, you need to send the more intelligent ones, because the ones you're sending right now, they're intellectual maggots and everything. They keep trying to bring these arguments about talking about statutes of what we believe. You believe you can drive. I mean, you can look up the word drive and see it's a commercial term. Why are you trying to act like it's not commercial, man? This is simple. Everybody can see it. Okay, I can just look at the Constitution and we'll see what's been delegated to Congress. Okay, and I can tell, and you can get in your state constitutions and see what's been delegated to your legislature, and you can tell what they have the authority to do and what they don't have the authority to do. It has to be commercial. It's not a thing we believe. That's the only conclusion. If it's not, they're acting outside the ambit of their delegated authority, and that means that they become personally liable for some things. If that's what you're saying, if you want to push that argument. But see, the thing is, y'all got the guns and everything. You're trying to foist these beliefs on the people. And that's why y'all are coming out like ants on all these videos and everything, because the people are waking up and they're tired of your shit. They're getting sick and tired of your shit. That's why they are attracted to something like this. They can listen to me and tell I'm not a damn fool. And you know it, too. That's why you're here. If I wasn't a threat, you wouldn't be here. You're deceiving the people. I mean, look. Yeah, you're deceiving the people. When they tell me that I'm deceiving the people, and don't y'all understand that is an insult to y'all? It's an insult. It's an insult to my listeners, because what they're saying is that y'all not intelligent enough to be able to be perceptive enough to determine whether or not I'm deceiving you. That I have to be in some kind of way. I'm just a dynamic speaker. And, y'all just like to hear me speak in some kind of way or something like that. But out of all the thousands of people that listen to me, ain't none of y'all more intelligent enough to discern what I'm saying, to go behind me and investigate what I'm saying and say, hey, this dude is a fraud or something like that. I'm getting 150, 200 subscribers a day. Okay, so all these people are just stupid. They're idiots. I mean, they're all walks of life. Doctors, even some attorneys and things like that. And you're just saying I'm, in some kind of way, I don't know what I'm talking about. I'm like, yeah, I know what I'm talking about, dude. I've been doing this for a long time. I'm not going to let you insult me and say that my 15 years of study and everything was for naught. I didn't understand what I was doing. It's crazy, y'all. Go on go on all of these different videos that you're going to see, because they haven't seen anyone like me. I'm different. Okay. But go on these videos and you'll see where they post the same damn comments on all the videos. Go look at some of these trolls. They got a couple of them. They got, it's like real prominent ones. Go look at their comments on some of the other videos. It's the same damn comments. They put the same damn, every now and then one of them will try to act like he's intelligent by giving some long diatribe of what we believe. This is what y'all believe in. You haven't proven anything. And then the logic that they have, it's like the court system is corrupt. You asking me, we're talking about the court system, but then you're asking me to prove something about the very court system that we're saying is corrupt. This is how these people are talking about. It is up to the people. Okay, it is us. We are the source of law. If government officials are not doing their job, it is for the people to make change. And that's what we're spurning. I don't know what you have a problem with, because that's our right. If you're not doing your job, you got to lose it. You're not supposed to have a job if you're not doing your job. And as far as I'm concerned, you don't understand what your job is. You have to be reminded of what it is. And you have tried to dumb down society. It did not work. It didn't dumb down everyone. This is why I'm reading these documents and everything, because I want you to hear it. I want you to see and understand what I'm reading. And you can keep posting and say that I don't. As I said, you don't understand. I'm looking at you. You are intellectual inferior. I descend from the people who created the pyramids. There's an awakening happening, a renaissance, if you will. And I know you're afraid. That's why you're hiding behind fake profiles. Keep hiding. Because if you had to come out of who you really are and take the position that you're taking a chance of being exposed of who you are and everything, that's a very big risk for you to take. Because the truth comes out. The truth wills out. Anyway, understand separation of powers, y'all. Study the principles. Okay? You have to understand separation of powers. All right, and understand how the judiciary interacts with the legislative and executive branches of government, the checks and balances that form on each one, how the judiciary is the watchdog of the Constitution and the protector of private rights, how being private is where you're supposed to be. Okay, this U.S. citizenship is not nothing. It was created by the 14th Amendment. You can read the case. Susan B. Anthony has a case that I think goes into it very well. I mean, they give a good description of it, how when the 14th Amendment came into existence, how it created another citizenship. Before the 14th Amendment, there was no such thing as a citizen of the United States. But they created it for the black people, so they say, and then they just put everybody in it as a U.S. citizen. But in order to do that, because under the Constitution, it tells them very clearly of what their jurisdiction is. It's that 10 mile square in D.C., as well as all their insular possessions. To extend that beyond that and stay in conformance with the Constitution, they had to make a territory that's fictitious. That's why they created Social Security numbers and straw man. And it's very easy to follow along. And they're trying to act like straw men don't exist and then turn around and act like Microsoft or the state of Georgia or something like that is real. The fallacy in your logic is just stunning, to us and everything. We're looking at you. I really believe we have the most intelligent people on our side. And I believe that you are the most dangerous and the most illiterate and most uneducated of the lot of the citizens in this country and everything. And it's a shame of what you're doing. We're sitting here talking about God-given rights. Every man has a God-given right to govern himself. Okay, you are the mob. You're attempting to have mob rule and try to force your beliefs on someone else. And this is called a free country. And don't get into this with me about public safety. I understand that. I have a respect for the government. Government is necessary. Okay, but we don't need big government. Okay, the only duty of government is to protect our life, liberty, and property. That's all I want government to do for me. Protect my life, liberty, and property. Okay, I don't need any government services. I don't need to be part of a welfare state that was created in 1933. You can look this up on Wikipedia if you don't believe it. Okay, ask them about the Social Security number. Well, it was created. If it's the mark of the beast that's being talked about in Revelation 13:18. Okay, this is the Social Security number, the mark of the beast.
Is it 666? I'm going to put back my video up on my video Abjad on 666 and let y'all see some things too. But we got to start exposing all of this stuff because these people, you know, they really trying to play you like you stupid and everything. That's where the insult comes in, because they think in posting something calling you stupid or illiterate, or you people try to misconstrue the Constitution and misconstrue statutes and all like that. No, it starts with jurisdiction, man. Understand what it is. It starts with a principle. And that's separation of powers, and what power has been delegated to a particular branch of government, what they have the ability to do that we said they could do. And I don't know, and they don't address any of this. They try to keep you in some argument about statutes and, you know, or something like that. And they don't want to talk about fundamental principles or fundamental rights or anything like that, or public versus private. I never see any of those arguments. They're all try to keep you constrained into some sort of discussion about statutes. Statutes are a derivative law. They're a derivative of the Constitution, and they only obtain in a certain jurisdiction, in which the legislature has plenary power. Okay, so I understand that, but I also understand what private rights are. Okay, I understand what that, and that's what I'm teaching these people. I'm teaching these people about their private rights. I don't know anything about a sovereign citizen. I do know what a sovereign is. I don't obtain to a sovereign citizen ideology. My ideology is the truth. Why would you let anybody label you something, try to put a label on you? Motherfucker, don't put no label on me. That's why every time y'all call me a sovereign citizen, y'all need to start calling these people lapdogs and sheeple. Start referring to them as the lapdogs. If they want to call you sovereign citizen, start calling them the lapdogs and sheeple. Peace to the gods.